Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. Some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that, because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
That is interesting. I mean, I'm just a lowly community college guy, certainly not a Supreme Court justice, but I always thought that the First Amendment, that was kind of the whole point of the thing. Let's ask Josh about this. Joining me now, my friend Josh Hammer, host of America on Trial with Josh Hammer. Josh, my constitutional knowledge is a little rusty, I'll be honest with you, my friend. Certainly not an intelligent individual, but I thought that was a little eye-popping to come out of the mouth of a Supreme Court justice.
Jesse, let me first say that it is one of the worst kept secrets of anyone who has ever gone through law school that the median community college graduate or dropout such as yourself probably actually has better instincts when it comes to constitutional law than probably 80 to 90% of those who graduate from Harvard, Yale, my own alma mater, University of Chicago Law School. So do not sell yourself short. I am seriously not just saying that to butter your ego. That is the current state of legal academia and in many cases the federal judiciary. Look, to me, this case, and I've been tracking this case for almost 2 years. This has been on my radar for a very long time. Eric Schmidt, the former attorney general in Missouri, he's now the junior senator in Missouri, alongside Josh Hawley. Eric Schmidt, back when he was Missouri Attorney General, he was the one who got this lawsuit going, along with his then Louisiana colleague, Jeff Landry. This was back in May of 2022 was when they first filed suit. And then you had a leak where the media started reporting, due to partially and perhaps in large part to Eric Schmidt actually leaking a lot of it himself. He made public a lot of the discovery, a lot of the documents and the communication that they got in the midst of this lawsuit. This was August, September 2022, right around Labor Day. And Jesse, it was explosive stuff. I wrote multiple columns on it at the time. The Biden White House, it was the HHS, the DHS, the actual White House itself, the FBI, you name it, the whole alphabet soup, CDC, how could I forget those lunatics? Basically, all of the alphabet soup of the Biden administration was in constant weekly or bi-weekly communication with all the big tech oligarchs, Google, Meta above all, Facebook and Instagram, and yes, very much so, the pre-Elon Musk Twitter regime. What were they doing? They were telling them to censor speech. They were telling them to algorithmically derank, to depress, to shadow ban, perhaps to outright ban, as the case may be, infamously with the Hunter Biden laptop. And when you look at this from a bread and butter First Amendment perspective here, you know, the First Amendment says that Congress shall make no law infringing upon the freedom of speech. The key word there is infringe. You know, is Congress passing a law here? Is the federal government passing a law to simply say you shall not speak? No. But the word infringe actually, and the concept of legally infringing more generally, actually has a lot more wiggle room in it than that. The government has absolutely unequivocally infringed upon many, many individuals' free speech rights over the course of this terrible, terrible experiment in corporate and public sector fusion, which is what we've seen. There was a remarkable opinion from District Court Judge Terry Doty down in Louisiana last July. Fittingly, it was on July 4th. That's fittingly because it was a beautiful pro-First Amendment, pro-free speech, pro-red, white, and blue Americana type of opinion, where he basically said that this is one of the most Orwellian attempts for the government to mass censor speech in the entire history of this republic. And his preliminary injunction was modified a little bit, but it was largely upheld at the U.S. Court of Appeals for the Fifth Circuit, which is the conservative leading appellate court that many years ago I clerked on myself. So based on my reading of the tea leaves, Jesse, this oral argument today did not go as well as folks like me had hoped it would. I'm hoping to be proven wrong when it comes time to release an opinion. I have to shout out to a friend of mine, Ben Aguinagua. He is the new Solicitor General of Louisiana. He got into that post just in January, an absolutely brilliant conservative attorney. He apparently did a great job today in court The problem is that none of the conservative justices, other than Clarence Thomas and Samuel Alito, seem to be buying it. That is their problem. That is their fault, because Louisiana and Missouri are correct to file suit on these grounds.
Okay. Can you walk me through that, Josh? And I know I'm asking you to put yourself mentally in someone else's shoes, but you have these supposed, conservative or right-wing justices or originalists like Gorsuch and Amy Coney Barrett and others. How are they not all over this too? How is anybody outside of an absolute apparatchik not horrified by the federal government using social media to censor speech they don't like? What are the others doing?
So here is why lawyers tend to make things more complicated than they are. So the relevant legal doctrine that is at issue here is state actor doctrine. And the basic question is, when does a private company's actions or a private company's speech become the government speech or the government's action? So in this case, the point that you're making, the point that I just made, and the point that Louisiana and Missouri made, is that these social media companies, Facebook, Twitter, became government actors when the federal government told them what to do. When the federal government said, you really ought to do this, or wink, wink, nudge, nudge, we're going to take away your Section 230 liability, or you really should do this, or wink, wink, nudge, nudge, we're going to probably break you up on good old-fashioned Teddy Roosevelt trust-busting antitrust grounds. And those threats were very real. They were shouting from the White House. The White House Biden administration public health team was openly threatening Facebook, Twitter, all of the above. Heck, I remember it was the summer of 2021. I remember when Jen Psaki, the current idiot's predecessor, I remember when she was up there openly hectoring and threatening Mark Zuckerberg and wagging her big finger and saying, oh, Facebook, you better censor these vaccine skeptics because we're trying to get all of America vaccinated. How dare you peddle misinformation? If you're Facebook, you look at that and you're like, wow, the government's telling me what to do, right? But for many, I think, libertarian-leaning jurists in particular, and Neil Gorsuch is a good example of this. He's a much more libertarian-leaning guy than, for example, Sam Alito is. He is reluctant to find state actor doctrine for kind of the old school notion that he wants to maximize private sector speech. It's kind of this idea that the best way to defeat Facebook and Twitter, if you don't like what they're doing, is to build your own Facebook, build your own Twitter, build your own Google, as we've heard the line say many, many times over the past 5 years there. So a lot of more establishment and libertarian-leaning jurists are, I think, very reluctant to find state actor doctrine where it is only debatable. Clarence Thomas and Sam Alito, because they're stalwart conservatives, have no such compunctions. But one final thing, Jesse, on this note, it's worth pointing out that it is black letter First Amendment constitutional law, and it has been black letter constitutional law for 50 or 60 years, that the government cannot immunize or otherwise induce private sector entities to do that which the government cannot do directly itself. The government cannot censor speech itself. What they are doing here is trying to immunize them by saying, oh, you can keep your Section 230 immunity if you do our dirty bidding. You can't do that.
Yeah. All right, let's switch gears here. Adam Schiff is all over the news, as he always is. About to be Senator Adam Schiff, going off about the Trump immunity case. Here he was.
The Supreme Court moved with great speed when it came to ruling that Trump could appear on the ballot. The question is, will it also move with great speed in rejecting this bogus immunity claim? If it doesn't, it's making a deliberate decision, essentially, to push the trial past the election. And I think that would be a terrible decision, both for the interest of justice. It would be a terrible decision in depriving American voters of the information they would learn during the course of that trial. But it would also just further discredit this partisan and reactionary court.
Josh, okay, setting Adam Schiff's moron mouth aside, where do you think we fall in this immunity case?
So let me make one point, though, about the point that Schiff is making, which is the idea that the Supreme Court is going to hand the election to Trump. Jesse, Jack Smith had a long time to file charges, didn't he? And he waited until June of last year to file his case in Mar-a-Lago in Florida, and then even later in the summer of last year to file his case in Washington, D.C. Why did he wait until the year prior to an election year? He could have easily filed those suits if he wanted to in 2021 or 2022. So if there is anyone to blame, if the federal prosecutions do not get up and running before November, which as of this point, I don't think they will, the blame goes to Jack Smith himself. Now, Adam Schiff's not going to admit that because Adam Schiff is a deranged loon bag. But if he was being intellectually honest, if he had a modicum of intellectual honesty left in his body, then he would look squarely at Jack Smith and place the blame with him. As far as the immunity question, which is going to have this huge hearing, big argument, I'm very much excited for myself at the Supreme Court in a little over a month now. I don't think that Trump's lawyers are going to get what they want and get absolute full sweeping immunity. You maybe have 2 or 3 votes for that at the most. I actually could see it not getting a single vote. But at the very most, you have 3 votes for that. Thomas Alito and maybe Brett Kavanaugh, who's a very pro-presidential powers kind of jurist. I think what's most likely here, Jesse, is you're going to get a mixed result where they basically say that some actions that a president takes in the White House do fall under the, quote, executive power of which Article 2 of the Constitution speaks. And those actions you are immune for criminal prosecution, but then there are some actions that are not immune. And to give like a very easy example, let's say that you fire a bureaucrat, you fire a subordinate somewhere, a deep state guy deep in the bowels of DHS or whatever. That is a core executive power function to run your administration the way you want. Any possible criminal liability for something that pertains to that action would be done. You have immunity. But if you want to hire an assassin to kill your mistress before your wife finds out, maybe then you can be subject to immunity after you leave office. So I think that the opinion is going to look something along those lines. So I'm predicting a mixed result, which, by the way, is actually in reality a pretty good result for Trump, because then they're going to have to kick that down to the lower courts for additional fact finding to see whether or not Jack Smith's alleged conduct in this indictment falls into bucket 1 of immune conduct or bucket 2 of not immune conduct. All of this is going to take a lot of time and kick the can down the road. Again, it's looking very unlikely that this trial starts before November.